Thank you very much to everybody joining us today. We have what is the third topic on specialized issues on international arbitration. For this occasion, I have the pleasure to introduce to my colleague, Dr. Anna Abbe, which obviously is a very well-known face by now. She was the creator and the mastermind of this special edition. And just as a brief commentary, I met Anna a couple of very good years ago. And as a matter of fact, she was doing her PhD on intellectual property and arbitration, which I must say is an unusual research to do. So since then, I have held a very high respect for Anna because she was one of the brave ones, and she continues to be one of the brave ones. And although she's a very young leading light, I can say very comfortably that in Mexico, she's perhaps one of the specialists in the combination of intellectual property and arbitration. So therefore, I am delighted to be able to introduce her today, and she will also tell you a little bit more of our three experts from today who are also leading lights in the interaction between intellectual property and arbitration. And I really hope you enjoy it because it is a very promising and a very interesting topic. Anna?
Gloria, thank you so much for your really kind and undeserved words. And I actually am super happy as well to have this topic today, because as Gloria said, it's very dear to me, and especially with the speakers that we have today, because the book of Trevor Cook and Alejandro García was just going out as I was starting my PhD. And of course, the honor that Abbe Brown also makes us in joining us from Aberdeen as well. And well, for our audience, thank you very much for attending to this session. We are delighted, as I said, to virtually host our speakers today, and we are thankful they accepted our invitation for this seminar. The format of the presentations is going to be a roundtable, as round as it can be virtually. Each of the speakers will have 20 minutes to talk about different issues concerning intellectual property arbitration. And after that, we're going to have a general discussion with further questions. And we will close, of course, with questions from the audience. So I invite the audience, whether you have questions while our speakers are talking, you can type them in the chat. So having said that, let me introduce our first speaker of today, Mr. Trevor Cook. Mr. Trevor Cook focuses his practice on transnational intellectual property litigation matters and is also active in the area of life sciences. Mr. Cook has more than 35 years of experience in global patent litigation, particularly in Europe and Asia. In recent years, he has acted in many of the leading patent infringement cases that have come before the English courts, most of which have concerned pharmaceuticals and biotechnology, and also many of the leading cases regarding the protection of the regulatory data. Mr. Cook has for several years been president of the UK group of the International Association for the Protection of Intellectual Property. He's chairman of the British Copyright Council and is on the World Intellectual Property Organization list of arbitrators. Mr. Cook is a prolific author, having written numerous articles and books during his career, and he is on the editorial board of Life Science Intellectual Property Review. Mr. Cook is going to speak today about the advantages of using arbitration for intellectual property disputes, the applicable law, arbitrability, and enforcement matters. And without further ado, I give the floor to Mr. Cook.
Okay, thank you very much, Anna. And hello, ladies and gentlemen. Anna has outlined what I'm going to be talking about. But before I talk about that, perhaps I could talk about two particular different types of IP arbitration and the context in which this arises. Because typical disputes concerning IP rights which are arbitrated arise under existing contractual arrangements, license agreements that contain an arbitration clause. And such you may have a patent license, and there may be a dispute as to whether the patents cover a particular product, so that royalties are payable under it. So that's probably the normal context in which this arises. But I also want to remind you that other IP disputes can be arbitrated once you've made them the subject of a submission agreement. And certainly I've had experience of that sort of arbitration where there was an international dispute, some decisions in some courts, some decisions in other courts. The parties started to get a sense of where things were going to land up in most areas, but there was one particular area, one particular family of patents they could not reach agreement as to. And they then decided that, well, they would they would resolve their differences, but on that particular family of patents, they would submit that to arbitration. And so that is a perfectly satisfactory way of dealing with such matters. And I think the parties were very satisfied, even the party that lost in that, with the way the procedure had gone. So you shouldn't only think of IP arbitration as happening in the context of existing licenses. If the parties agree, they can sort out any dispute between them by IP arbitration. So let's talk about some of the benefits of IP arbitration. There are obviously the usual benefits you get with any arbitration: party autonomy, neutrality, expertise of the tribunal, finality, if that is what you want, confidentiality. And we'll come back to confidentiality because that's quite interesting in a way, and ready international enforceability, obviously under the New York Convention. But there are some benefits which are specific to IP arbitrations. I've already alluded to the whole question of the identity of the arbitral panel. You can tailor the composition of the tribunal to the needs of the dispute. If it needs some technical expertise on the tribunal, for example. You can also tailor the procedure to be adopted, and you can tailor the nature of the relief. Do you want to exclude, for example, in a submission agreement situation, do you want to exclude injunctive relief, or do you just want to have, or do you want to exclude triple damages or something like that? What this also provides is scope for the parties to resolve their disputes between them without necessarily affecting the IP right in rem, the underlying IP right. And this relates to the whole question of arbitrability, which I'll come to talk about. Because in a sense, although people suggest that, well, the fact that you can't, in most jurisdictions, actually invalidate an IP right in rem as against the whole world, but only effectively invalidate it as between the parties, they suggest that's some sort of problem in arbitration. I would suggest otherwise. I think that for the parties to arbitration, that is probably something of considerable interest and a considerable attraction for them. But I think the biggest reason for IP arbitrations and the biggest benefit of international IP arbitrations is the scope to resolve multi-jurisdictional disputes under multiple laws which relate to the substance of the dispute in different ways in the one single proceeding with the one set of evidence and with the one arbitral award. And I don't think one can emphasize, well, once you get involved in multi-jurisdictional IP litigation, you rapidly recognize the value of being able to resolve all this in the one proceeding. Because intellectual property laws, they are national or at most regional. Few courts are prepared to adjudicate on foreign IP rights. They regard those as being a matter very much which is key to the national jurisdiction under which those IP rights are granted. Judgments tend not to be enforceable abroad. And so, you have all these jurisdictions, you have all this potential for all of this parallel litigation going on with sort of arguments which are good in one country, potentially undermining you in others, and all of those sorts of considerations. So IP arbitration really does offer something very special from that in an international context. I think I'll come on now to talk about the whole question of arbitrability of intellectual property. And I think this is something which depends on the background to which you come at this. I think a pure IP lawyer finds it quite hard to sort of think about, well, patents, trademarks, these are things which, they're granted by national patent offices, national trademark offices. How can you invalidate them? But I think when you're thinking about it, IP arbitration, you have to differentiate between the rights as between the parties, the status of the dispute as between the parties, and the status as regards the world at large. And yes, very few jurisdictions regard IP rights as being arbitrable in the sense that a determination of an arbitral tribunal that, for example, a patent is invalid has effect against the world, and that the IP office has to take that on board. But actually, when you come down to it, that is the only sort of constraint on IP arbitration internationally, even though you will find all sorts of learned writings about this. Not so much in recent years, but certainly you go back and nobody was making this distinction between the in rem effect of an arbitral award, which is very limited, only a few jurisdictions, and the in personam effect as between the parties. And I think once you see that, once you bear that in mind, all of these concerns about the arbitrability of IP fall away. I mean, to go to a few specifics, South Africa, for example, is often given as an example of a country which doesn't allow the arbitrability of IP disputes on the basis of wording which was not directed to arbitration at all, but which says that only the court or the intellectual property office can determine the validity of an IP right. Well, fine, but that's not excluding it as between the parties. What you're seeing more of these days, however, is a recognition in the statutes that parties can actually resolve these disputes between themselves by means of IP arbitration. One of the first ones to do it was actually the United States, although oddly enough, US lawyers seem to be pretty unaware of this particular provision in their code, but it specifically states, and it's 35 USC 294, that parties can arbitrate, that parties should actually, parties will arbitrate US patents, parties should actually notify the patent office about that. But it makes it quite clear that the effect is between the parties and not in rem. And you've got a similar sort of provision in the agreement which underlies the Unified Patent Court. And more recently, you've got the Hong Kong Arbitration Amendment Ordinance of 2017, which introduces this, says you can litigate IP rights, but the effect is between the parties and not in rem. And most recently, Singapore, in its only about a year ago, in its Intellectual Property Dispute Resolution Bill, passed at the end of 2019, introduced the same sort of principle in Singapore. Now you can contrast that with a few other countries where the effect of arbitration awards is expressly stated to have effect in rem. And the two I'm aware of are Belgium, which has that in relation to patents under Article 51(1) of its Patents Act, and Switzerland, which has it in relation to all intellectual property rights. So yeah, that's really where we stand in relation to that. I've got 5 minutes to talk about applicable laws and enforcement issues. I mean, I think and applicable laws, this is really going back to international disputes. And I think when you look, for example, at the WIPO rules and Article 61 of the WIPO rules, it sort of recognizes, although it doesn't spell it out quite in terms, that in any international arbitration, you're going to have 3 sort of laws you're going to have to take account of. There is the law of the arbitration agreement itself, the arbitration clause itself. There is also the law of the seat of the arbitration, which not actually the place where the arbitration physically takes place, if these days it physically takes place anyway, but certainly the court system which you have recourse to when you need to, when you're looking to enforce an award or you're looking for some guidance in relation to the arbitral process, but also the substantive law of the dispute. And in most disputes, virtually the vast majority of international disputes which get arbitrated, you've got a single substantive law. But in intellectual property, multiple intellectual property arbitrations, for the very reason I gave as being one of the benefits of international intellectual property arbitrations, you have multiple substantive laws. And so the arbitral tribunal has to address those. But it doesn't always have to address them by saying, this is the law of this country, this is the law of that country, this is the law of the other country. It is certainly possible for the parties, and some of the examples on the WIPO website give this. Certainly possible for the parties to say, well, we've got this international dispute, but let's determine it under, say, German law, for example. And I had an arbitration where I was sitting as the arbitrator and for a dispute which was Europe-wide. And I mean, even though we're all working in Europe under the same black letter patent law of the European Patent Convention, how we actually apply it in practice is much more granular. There is much more there is much more fine detail, and it's the fine detail which really matters. For example, if you're looking just at the question of infringement, forgetting questions of validity, if you're looking at the question of infringement, there are different rules on equivalence between patents. How broadly do you construe the claims of the patent to read onto the infringement, or the alleged infringement? There are different approaches to file wrapper estoppel, which is a US concept which has been imported into Europe. Can you limit the expansive scope which you are being asked to give to the claims of the patent by reference to what the patentee said in its communications with the National Patent Office? And so, I mean, I had this arbitration which involved multiple European jurisdictions, and the sort of first set of evidence, it flagged up these different issues, these different approaches to infringement in different jurisdictions. And I had a procedural hearing with the parties, and I said, well, really, where are we going with all this evidence about differences in national laws? Is this going to be a big thing? How are we going to develop this evidence? And the parties sort of hummed and hawed rather. They left the position open as to certainly the issue of infringement. But I suggested to them, at least as to issues of validity, which, if you like, is rather more harmonized in a sense because that's what the European Patent Office concentrates on. I suggested to them that from point of view of issues of validity, they adopt the case law of the European Patent Office, but if they wanted to argue any specific point of national case law, they flagged that up in advance before we had any sort of evidential hearings. But the interesting thing which developed in this case as time went on was actually that the national differences in laws disappeared. The parties, neither party was making much of the national differences in laws. And when I started thinking why this should be, the answer is very obvious, that the parties, if you start saying, well, there's this really important feature of national law, which means I win in this jurisdiction, you're also at the same time saying, actually, my argument is not so good in other jurisdictions. So what you come to naturally is a sort of common denominator of patent law. Now, it may not reflect what would actually happen before a national court in those respective jurisdictions, but what we're talking about here is a problem-solving exercise. How do you resolve this dispute as between the parties? And so I found it very interesting that even though they'd started off with all these different national laws, and I thought I was going to get stuck with having to make rulings about, in the award, with having to make determinations about where these national laws stood. At the end of the day, the parties didn't say anything about that. It was a sort of common European, albeit artificial, but a common European framework. And certainly I'm aware of another arbitration under the WIPO rules where the parties realized that up front, and they said, we'll just do this under German law. We'll resolve the whole disputes throughout the world under German law. And that is, that is what party autonomy allows you to do. So, but otherwise, if the party's not going to do that, well, you've just got to deal with applicable law by applicable law. But I don't think in practice it's such a real issue as people may make out, because for the reasons I've given, parties don't make so much of applicable law when you come down to it at the end of the day. Their case has to be convincing across the board, not just in one specific jurisdiction. So in the last few minutes I have, before handing over to Alejandro, my co-author, and one of these days we'll get round to writing that second edition, won't we, Alejandro? Yeah, he's smiling. But just before I do that, a few thoughts about the enforcement of awards in arbitrated IP disputes. Now, clearly going back to the question of arbitrability, this is one of the sort of underlying concerns. People say, well, how are you going to be able to enforce an award in relation to a matter which is not arbitrable? But it is arbitrable inter partes, and we're not suggesting that a local patent office, unless it be in Belgium or Switzerland, implements the arbitral award. The arbitral award is sufficient as between the parties. And so in practice, IP arbitrability is not an issue. And I've raised this with the people who administer the WIPO rules. And you thought if they were going to get issues of arbitrability, they would be the ones who experience that, and they've never experienced such a problem in practice. And one also sees cases, for example, where courts will actually enforce arbitral awards or respect arbitral awards, which actually differ in outcome from how those courts themselves would have ruled. And there's a very good example of that in recent litigation between Sanofi and Genentech. We had a sort of aspect of that in Europe, but actually most of the litigation was taking place in the States because that's where the money was. And the arbitral award found there to be infringement, whereas applying US law found there to be infringement, whereas in separate US court proceedings, the US courts found there not to be infringement. But then when the defendant sought to stay the arbitration award and challenged it, the US court said, no, arbitration from a public policy point of view is something we should respect. The interesting part of that dispute, and I know Alejandro has written on that in the CLUA arbitration blog a few years back, is the other side of it in Europe, because in that, the Court of Justice, there was a challenge to the award, which got to the Court of Justice. But that was on the basis not that the arbitral award, not that this was an impermissible IP arbitration, or not that this was an impermissible question of arbitrability, but rather that the license agreement under which the arbitral award had been made was in fact contrary to EU competition law. The Court of Justice held in that case that it was not contrary to competition law, but certainly the Court of Justice did make it quite clear that it was prepared, it was not, just because it was dealing with arbitration in this case, it was not going to give it a free pass because it was an arbitration if there was an underlying concern about competition law. So that remains, if you like, a potential constraint on IP, at least under existing license agreements. And when you think of it in practice, what is wrong about an award by which somebody says, well, if it goes against me, if a defendant says, well, if it goes against me, if the right is found valid and infringed, I won't do this anymore, as opposed to a defendant who says, well, or a plaintiff who says, well, if it goes against me and the right is found invalid or not infringed, then effectively the defendant gets a royalty-free license. These are the sort of decisions which parties can make in the context of negotiations between them, and which they make every day in negotiations as between them. So all that is happening in the context of arbitration is you're asking somebody else, an arbitral panel, to make that decision for you. And that, I suggest, is a very good example, is a very good way of resolving disputes, which certainly these days rarely take place and rarely concern one single national jurisdiction. So with that, come up to my allotted time and I'll hand over to Alejandro. Thank you very much.
Thank you so much. Before passing, I just want to introduce our next speaker, Mr. Alejandro García. He's a partner in Clyde & Co. in London. Alejandro has acted as counsel in numerous complex international arbitrations, both ad hoc and under the rules of the major arbitral institutions. And these arbitrations have encompassed disputes in a number of sectors, including renewable energy, oil and gas, infrastructure, intellectual property. In 2015, he was recognized by Thomson Reuters as super lawyer in London, and he has also been recognized as a rising star in the field of international arbitration by Who's Who's Legal. Alejandro obtained his LLB at the University of Chile, where he graduated summa cum laude, and he's had an LLM from Harvard Law School, where he had a Fulbright scholar, when he was a Fulbright scholar, and he's admitted to practice in England and Wales, New York, and Chile. And Alejandro has written extensively on issues of commercial arbitration and investment treaty arbitration. And well, today Mr. Garcia is going to talk about a few issues on arbitration, commercial arbitration of intellectual property, and he's going to give us the introduction to the investment arbitration of intellectual property. The floor is yours.
Thank you, Anna, and thank you, Gloria, for the introduction, and thank you to the audience. Thank you, Trevor, for the words. Yes, the second edition probably will have to wait a little, but it's a busy time. But I think it would be good to do it. But well, we have to have that chat at some point. But I'm keen that we do it. But you know, it takes a lot of time. It's an interesting topic, but complex, and there's a lot, I suppose, going on. So I will discuss 4 topics. The first one, I will talk about institutions that provide IP arbitration. Then I will discuss type of IP disputes resolved through arbitration. Third topic is conflicts that involve multiple jurisdictions, and Trevor touched upon that briefly, and perhaps I can just provide a few comments on that. Then I will discuss a little bit about investment treaty arbitration and introduction. I know Abbe will be discussing some cases involving IP as investments, but I will provide a brief introduction to the subject, because I'm increasingly doing investment treaty arbitration sort of the last 6 or 7 years. So let me talk first about institutions that provide IP arbitration. And I will talk about the sort of WIPO, the leading institution. I know the number of institutions out there that either have specialized rules or they might specialize in IP arbitration, but the leading institution is WIPO, and I have to confess that I'm a bit biased because I worked at WIPO for 1 year between 2006 and 2007, and as a result of that, I met Trevor back in the day. So that's the genesis to the book. So even though perhaps I sort of have to admit that I'm a bit biased, so the WIPO is the leading institution in terms of IP arbitration in the world. So WIPO is has an arbitration and mediation center, and WIPO stands for the World Intellectual Property Organization. So it's part of the United Nations system. And the center as WIPO is based in Geneva, Switzerland. So the WIPO Arbitration and Mediation Center was established in 1994, so quite a few years ago. The rules have some special features that deal with IP issues. The latest version of the rules were issued in 2014. I suspect they might also be thinking about updating the rules. I haven't had any discussions with WIPO on this, but there's a trend. A lot of institutions are updating the rules. We have seen the LCIA rules, the ICC rules being updated, so I suspect they will follow on the trend. So the WIPO rules are really sort of very modern, I would say an excellent set of rules for IP disputes. And some of the specific features you have in the rules relate to confidentiality, experiments, and site visits. So confidentiality is very interesting because the WIPO rules took a view, I think from the genesis, and perhaps the rules in 2000 when they were formulated, perhaps in a way which is closer to what you have now. Everything is confidential in a WIPO arbitration, even the existence of the arbitration, which is something I would say rather unusual. But it's because WIPO took the view that some of these disputes are particularly sensitive. There might be trade secrets at stake, and so parties have concerns about the reputational damage of the arbitration. Of course, if there's a challenge against the arbitral award, the award will become part of the public domain in most countries. But it's interesting that WIPO took a very sort of broad view on confidentiality, special provisions on experiments and site visits. And so overall, I would say not too different, say, from the ancestral rules, but with some specific features that make them particularly apt for resolution of IP disputes. Now, because they're so broad and similar to the ancestral rules, they can be used for the resolution of any sort of disputes. And I think WIPO sometimes they see pure commercial disputes. So it's not only about IP arbitration necessarily. And they have provided me. Provided me with some statistics, but I don't have slides. But I can mention some of the statistics of WIPO. So the increasing caseload. So for example, in terms of disputes, they don't have a breakdown between mediation, arbitration, expert determination. But say in 2018, so disputes, which encapsulates mediation, arbitration, and expert determination, were 24 disputes that year submitted to the WIPO rules. And in 2020, 57 disputes have been submitted. So it is a growth. It is not necessarily massive. Sort of 2019, the complete year, there were 62 disputes submitted to WIPO. So, of course, it is significantly more than 2008, but it takes time. And I think that's the reason why it takes time, and perhaps this deals with the second topic. Why it takes time for an arbitration center that specializes in IP disputes to increase its caseload is because most disputes involving IP tend to be infringement disputes in general, worldwide, if you wish. And of course, in most disputes, infringement disputes, you don't have an agreement to an arbitration clause. You might have, Trevor mentioned that some cases in which rather sophisticated players agree to on a submission agreement and to have a dispute that is existent to be decided by means of arbitration, but that tends to be rare. And so that's the reason, I suppose, it takes time also for parties to start having WIPO arbitration clauses in their agreements. So there's a time lead between sort of the rules, the institution, and the caseload to increase. But you see an increase. I think quite a number of disputes also even involving IP are resolved under the ICC rules and also the LCIA rules, and also so Hong Kong's all the other rules too. But as I said, I mean, because it takes time for a dispute to arise, and sometimes parties don't have a dispute, which is probably the good thing. So you can explain why it takes time for the caseload to continue growing, but I would say it is significant, and many of these disputes can be quite large, and sort of some of the disputes in which Trevor was involved were very, very large. Without telling more, because everything is confidential, of course, under the WIPO rules. So that I would say in terms of type of disputes, most of them are contractual, because of the reason you need to have a persistent relationship. And in terms of sort of WIPO has provided those slides, probably can ask WIPO if they can release those slides after the event, but you can see sort of the out of the disputes, the WIPO caseload, 25% of the disputes relate to patents, which is very interesting. Then you have so technology, sort of we call ICT, mobile apps, outsourcing, systems integration, software development, software licensing, and telecoms, 22%. Then you have trademarks, is 20%. Commercial, what they call commercial, is just design, distribution, energy, franchising, marketing, and sports, 20%. And copyright, 13%. So that's the breakdown, which makes it interesting that patents is the sort of the most common type of dispute, and I suspect it's because it tend to be large disputes, maybe multi-jurisdictional disputes. And WIPO are also very happy to say that they have a high settlement rate, including WIPO arbitration. 33% of WIPO arbitrations are settled. And those are the things that for litigation lawyers is really sad, but for an institution is really good. And also maybe for arbitrators too, it depends on the case. So so that's the type of dispute most common see. So pretty much any type of dispute can be submitted to arbitration. As Trevor mentioned, it really is up to the parties to decide what disputes they can submit to arbitration. And considerations sort of a public policy tend to be in most countries not relevant. They wouldn't give rise to issues of public policy if you submit a dispute to arbitration, including in relation to the validity of issues. So then in relation to multi-jurisdictional conflicts, yes, I mean, and Trevor touched upon this sort of in terms of can an arbitral tribunal decide on sort of issues of infringement in multiple jurisdictions? Yes, this in principle, there's no issue with that because so the whole question about arbitrability, I don't want to rehearse or repeat what Trevor said, but the issue of arbitrability ultimately is a question of public policy. And the question is, are you going to offend public policy by submitting the validity of a dispute to arbitration? And in most cases, the answer is no. And it might be that even you can use a concept that comes from France, but is that the international public policy that is only very, very serious issues would give rise to those concerns, such as modern slavery. And you can't really equate the invalidity of a patent of a registered right with those very serious issues. So I would say there's nothing in principle in relation to submitting multiple disputes, multi-jurisdictions. Trevor also mentioned that if the parties agree to that, the tribunal can apply, say, one law to all the different disputes. There's no issue with that. I suppose the question arises when a party that has agreed to that loses, because everything is very nice when you agree to that. It's just, when you say you're getting married, it's all fine, but you are having a divorce, then things don't look the same. So, and I think that is, I suppose, the issue that you face in an arbitration is, say, a party might have agreed to say, well, the tribunal may invalidate that patent or that right, but then when you lose, you say, well, hang on, couldn't agree on that. So that is, I suppose, when concerns and issues could arise. But in most cases, I would think that domestic courts would say, well, look, if you agreed to this, your eyes were wide open. There's not really an issue that you can address this way. So I think there might be issues of waiver. But again, I think the concern might be sort of if a party that loses an arbitration, what they would do. But again, I think in most modern arbitration-friendly jurisdictions, I don't think you would have an issue because a tribunal invalidated, say, a right, because ultimately, as Trevor explained, this is only inter-parties, so it only pertains to the parties. You're not necessarily invalidating the right, except for Belgium and Switzerland, which take a rather liberal view on that. But that's, I suppose, a different issue. So no issues. I think what is why perhaps IP arbitration is not as popular as one would expect is simply because most disputes arise out of there's no relationship, no pre-existing relationship is infringements, and people tend to go to court for those. And we can explain that when we talk about injunctive relief at some point, we can touch upon that a little bit more. So, and I'm conscious of that I don't have a lot of time, so now we'll talk about a bit about investment treaty arbitration. So I mentioned I'm doing quite a bit of investment treaty arbitration. It tends to be that Latin American countries get sued, and you have a few of those cases, and Spanish language skills are very useful. They become handy. So I haven't done investment treaty cases involving IP as such. But I will be providing a brief introduction to investment treaty arbitration. So you have, it's an interesting field. There's a lot of press, arbitration press. It tends to cover a lot about investment treaty cases. Why? Because most awards are published. So particularly sort of is at IIJ, awards tend to be published. So it gives journalists material to discuss. But the reality is that in terms of arbitration, most of the arbitration worldwide relates to commercial arbitration. But again, in many cases, commercial arbitration is confidential, or parties keep them confidential, so they don't get all the press that investment treaty arbitration gets. So investment treaty arbitration, is perhaps revolutionary in a sense that it allows a private party to sue a state. And that was very different from what existed before these treaties started to crop up in the 70s, that parties needed to ask their own government to sue the offending state, which is called diplomatic protection. So it's very interesting, new mechanism. And there's a network of 3,000 treaties protecting investments worldwide. So, and just briefly to mention, in many treaties, many such treaties, IP rights are considered to be an investment. And I will let Abbe to explain more about that. Now, what I think is interesting is just, there's a, I wouldn't say a problem, but there's something that it is very sort of confusing of investment treaty arbitration, is the notion of investment. Because I think sort of perhaps it's difficult to sit in judgment and say that 3,000 treaties have been poorly drafted. But the reality of it is just the term investment is actually not the best choice for these treaties to do what they want to do. Because the definition of investment in most of these treaties relates to rights, for example, property, IP rights, etc. Different, what you would say, just simply the rights of interest or types of property. So, and you say, fine, if you want to say that a type of property is an investment, and that what the treaty says, you say, well, fine. But the problem arises when people start thinking, well, but investment must be something else, because an investment is a financial concept or a concept of economic science. And then the problem arises because you have something that say, well, it is a right, but then you say also, if you try to translate that into a concept of financial concept, say, well, but you need also to contribute something to the country. You need to do, develop. It has to be long term. And sometimes you say, well, if it's a right, if it's a contract, some contracts are investments, and then many of these instruments, you say, well, but hang on, I don't understand why. Then you also ask to a concept that relates to rights and property, why you want that to have features of a concept that is a different science. So that creates a lot of confusion, a lot of issues. And I think perhaps also it can be daunting perhaps to say, well, why a trademark would be necessarily an investment? You say maybe not from the viewpoint of sort of the financial of economics, because you say it's a right. But if the definition, if the treaty defines a right as an investment, that should be enough. Now, there would be questions, and they say the IIJA Convention, which is a forum, and it's called the Salini test, where mixes, brings into the discussion the concept of the concept of investment, but from the other angle of a concept of economics from the which makes things a bit interesting and perhaps complex. But I wanted to mention that it probably would have been better just to call property to the rights, like sort of all treaties would talk about the protection of property of aliens in a country. Perhaps that was a better name to that. Then would have solved all the issues we see now. And clearly, if an IP right is a type of property, it's a right, and it's a right that you can oppose. If we use that sort of opposable, use a French probably type of imported loan word, it's a right you can exercise against anybody in the world, and so it is a right, and it should be, if it's defined in the treaty, an investment. But again, it has some tension there. Maybe Abbe can sort of might have a view on that. But I thought an interesting point, and that's why investment treaty arbitration can be a confusing discipline. It's just because of perhaps drafting was not the best one. But who I am to criticize that. So thank you.
Thank you very much, Alejandro. Thank you very much, and also for introducing the topic. And now we have our third speaker, Professor Abbe Brown from the University of Aberdeen. She was a lecturer in information technology law at the University of Edinburgh and an associate of the Scrip Research Center. This was in 2012, and before returning to academia, Professor Brown spent almost 10 years in professional legal practice in London, Melbourne, and Edinburgh. And 2018, Professor Brown has been involved in negotiations relating to the UN Convention of the Law on the Seas and areas beyond national jurisdiction, with particular reference to intellectual property, access and benefit sharing, technology transfer, and the ecosystem approach. Professor Brown provides consultancy activities, notably regarding thought leadership and innovation. She is the vice chair of the British and Irish Law Education and Technology Association, and she maintains links with the legal profession and industry and is involved in public engagement activities, impact generation, and knowledge transfer. She is also involved in the Scottish Law and Innovation Network. Today, Professor Brown is going to talk about two important cases on the field of investment arbitration of intellectual property. Professor Brown, the floor is yours.
Excellent. Thank you for nodding. Always reassuring. Great. So thank you, Anna, and thank you, Trevor. Thank you, Alejandro. Really enjoyed hearing what they're saying. Trevor talked about pure IP lawyers. I think I'm one of them. So it's wonderful to be able to approach this issue very much from that side of it. Really looking forward to the discussion. I suspect you know a lot more about arbitration than I do. What I'm also quite obsessed with is, although I am a dyed-in-the-wool IP lawyer, I'm very interested in how IP law intersects, or indeed doesn't intersect, with other legal fields and how that can impact upon addressing key societal challenges. I've done some work in climate change, I've done some work in health. And what I really like about investor-state dispute settlement, building on what both Trevor and Alejandro were saying, is the ability to draw things together in perhaps a very controversial way, but an ability to maybe have all the disputes brought together in the one place. But not everyone's happy. So I'm going to look at two particular cases and then a little bit on a third under the heading Forum, Framing and Fear. My screen's Things are probably off my screen, that's fine. So I'm going to give an overview of some realities of IP investment arbitration based on two decisions which have involved a state being quite innovative, I'll use that fairly neutrally, in passing legislation and in some approaches it's taken to its patent case law. And this, I think, does set the scene for future approaches to IP, ISDS, and most importantly for our discussion today. So firstly, we have a dispute between Philip Morris and Uruguay based on the Switzerland-Uruguay BIT under ICSID. Now, on the surface, we can frame this that Uruguay passed legislation about plain packaging of cigarettes. Now, you may or not be familiar with, but in essence, this says you're not allowed to have, say, Marlboro on the cigarette. You've got to have a picture of, someone dying. And lots of strong health reasons for doing this. But the tobacco companies, understandably, not terribly keen on this. And one of the many angles they have pursued was to challenge this on the basis of the trademark. So the particular decision which was made here was that you have a trademark, your trademark is still being used, it still has some value, so it hasn't been taken away, so there has been no interference with your investment. Digging down a little bit more, they said there had been no evidence of any representation on the part of Uruguay that they were not going to make any changes in relation to tobacco control. And also considered that, as well as the obligations in relation to investment, that Uruguay still maintained its rights, and in one of the judgments, the decision's references to a power to protect public health in a non-discriminatory and appropriate manner. And this I find is particularly interesting because one of the fear factors that we see when intellectual property and other disputes are moved into the ISDS framework is that some of the wider frameworks, wider legal regimes, which I know we're going to discuss, might be ignored. And this wasn't what happened here. It was considered that Uruguay still, even with its investment responsibilities, had legitimately exercised these other points. And what I also find quite interesting is that the decision said particularly you're trying to implement a World Health Organization set of guidelines. That's what you've done. It's a perfectly reasonable thing to have done. What we see underpinning this decision are some really, really interesting points for a dyed-in-the-wool IP lawyer. Because yes, there's the point, is it an investment? Is it property? It clearly is property, even though some people fight about that. But what power does a trademark give? What power do any IP rights give? And in essence, I really love to discuss this if people disagree, but in essence, they are negative rights. They give you a right to exclude. Philip Morris has the right to stop other people using their trademarks. that is not the same as they have a positive right to do it. And this is fairly well established in IP law, whereas I think that can seem slightly unusual when viewed from an investment perspective. What also I think is interesting and has received, again, a little bit more from the fear factor, was the fact that a part of the decision, and possibly a big part of the decision, was the decision that the trademark still did retain some value, even though you couldn't actually put it on the cigarette packages. So there is some concern that, well, what if the trademark didn't have any value? And there might we be seeing a fight between the legal power which a trademark gives, which is the right to exclude, and the investment value of it, the investment representation of it, which may be considered to be of value. So that power fight continues. It sits alongside at the same time another case involving Philip Morris and Australia, this time under the Hong Kong and Australia bit. And this, again, I think is interesting from the point of view of fear. So the main takeaway from this was that although Philip Morris had done quite a lot of corporate restructuring to try to have the relevant company who owned the relevant Australian trademarks based in Hong Kong, the panel wasn't having any of this and saying that was an abuse of rights. These are not legitimate investments covered by the agreement, even though a trademark could be. And so the panel had no jurisdiction. And the final point I want to introduce is to comment on Eli Lilly and Canada, which was a dispute under NAFTA. And on the surface, this, I'm going to love to know what Trevor thinks. This is a fabulous case for patent lawyers. We love this type of thing. It's the finer points, all those things. What does infringement mean? All of that. This is like what this case is about. The meaning of useful. No one knows what useful means. But here the court took a quite innovative approach to what useful meant. And it meant that Eli Lilly got their patent taken away. Eli Lilly, perhaps surprisingly, not terribly happy about this. So they then challenged Canada on the basis of NAFTA. And they argued that Canada had acted inconsistently with a minimum standard of treatment requirement under NAFTA, and that Canada should not be able to be innovative in its patent law. The panel held that, yes, it would interfere with national court decision, but only if it was egregious, a gross denial of justice, manifest arbitrariness, blatant unfairness. And the court considered that the panel considered this was not what the court had done here. And if we drill under that, what we saw the panel finding is that what the Canadian court had done flowed from previous case law. It wasn't actually a particularly radical innovation. It was new, but one could step where this had done before. And also that investors should not be able to assume that the law is not going to continue to evolve and that some inconsistency is to be expected. And I think, again, this is quite interesting from what Trevor and Alejandro were saying. IP law, like all areas of law, of course, but particularly IP law, it very much evolves. It's very, very contested. So this brings me to why I really enjoy working in this area. Clashing of worlds. One can very much frame, I think, IP and ISDS as a clash of worlds, and building on what Alejandro was saying. So should we even be here tonight, wonderful as it is, should IP be part of this debate? And there's a strong view that it's not an investment. And this is so even if an increasing number of agreements are actually listing IP as a protected asset. In Eli Lilly in Canada, interestingly, although they fought on all sorts of things, there wasn't a challenge on whether the patent could actually be treated as an appropriate investment. If we approach this from the IP world, who obviously are not particularly keen for ISDS to come involved, apart from me, I think it could be rather fun, but particularly people who are concerned that IP right has too much power. It is restricting the innovation of others. For example, it is restricting open and free access. A classic example today is obviously a COVID vaccine. If this was to be done, everyone should be able to share it. So while we have a lot of activity, maybe from human rights, from the climate change angle, trying to narrow the power of IP, there's real fear that ISDS could jump in and stop that. So arguments which from that background tend to be raised are that IP is intangible, Now, that's really not going to fly. Yes, it is intangible. That doesn't mean it's not property. It doesn't necessarily mean it can't be an investment. Obviously, compared to the classic, say, oil rig or pipeline example, that is a difference, but I don't think that in itself is particularly compelling. There is a point about a limited term, unless you keep your trademark, don't make it go generic, like say Hoover or Whirlpool, something like that. You keep paying your fees, trademark will last forever. Other than that, your IP rights will eventually expire, which has been argued to be different from some other forms of investment. That IP rights are argued too. I'm delighted to see some of my students are here. We know this is at least a starting point, that IP rights does reward and encourage investment, maybe, rather than this being a direct flow from you get an IP right, so the country has particular benefits from what you have done, say developing a new drug. Also, as again, Trevor has been noting, I might have a patent in Mexico. I might not have done anything in Mexico. I just ticked the box when I applied for my choosing the countries through the World Intellectual Property Organization, which countries I wanted my patent in. So there's many distinctions that we can see. IP also, building on what I was saying before, has a very strongly debated public-private fight. You're giving a private right to someone to control the results of their innovation. And the reason you're giving that is because eventually everyone else is going to benefit. But a big fight, should the others be able to benefit perhaps a lot more quickly. Then the final point is maybe what you get, as we saw with trademarks, you get a right to exclude, as opposed to a physical thing that you might be able to work with. So these are all the whole fights about whether or not IP should be here or not. It also sits alongside not just the debate from perhaps the more philosophical, theoretical point of view, but TRIPS, the World Trade Organization agreement, which has an IP section. It says that you can have set exceptions to an IP right. Examples might be in education, they might be in relation to health, there might be forced sharing, compulsory licensing, for example. And all of these could be relied upon by a country to narrow the scope of their IP rights to try to deliver human rights, climate change, and to engage in that. What I think we have really seen is huge fights about should IP be part of this debate at all. And we've also seen this really continuing. There's been another fight involving Canada in relation to copyright, geospatial information, basically where the oil exists. And we have seen a Canadian court interestingly taking a view finding against the IP owner and saying, we meant you were to share the oil and gas information, but where it is located and the fact that you think it is the subject of copyright or that it's trade secret is not enough. That has been challenged in one of the final NAFTA-based disputes. So that fight is going to continue. That I think is very interesting because whereas, again, an IP lawyer, we tend to say, well, IP always wins over human rights and climate change. We know it kind of shouldn't, but it really always does as a matter of law. This decision in energy was quite interesting because oil and gas is just as important and as well funded and has just as strong lobbyist as IP does. So it was very interesting to see that IP really could lose, but when IP has lost, it again is going to pursue its challenges elsewhere. So we see IP does lose, but IP will keep fighting. We will see that even the fact that all the cases I have explored, the IP owner hasn't actually won, but there's tremendous fear going through the IP community. And if anyone is working with clients and feels able to share that, it'd be really interesting to know more. The fact of being taken to a new forum is giving rise to a great deal of fear. The fact that if you can persuade a country to have perhaps innovative compulsory licenses on the COVID vaccine, would you really do this? Would you be too scared you would end up with another parallel or further area of inquiry? The Eli Lilly decision has been called the incredible shrinking victory. People thought they'd won, but actually that innovative approach, it's kind of disappeared. However, I still do think it's quite interesting to have the opportunity to look at investor-state dispute settlement. It can enable the real parties to come together. Perhaps it can enable the real issues to be considered, perhaps in a fairly neutral way, but I don't think I really mean neutral, because again, whether you start with IP or whether you start with investment, something is probably going to come first. I wonder, is this the end of the road? For example, in the Eli Lilly Canada dispute and the GSI Canada dispute, you've gone all the way up to the Supreme Court. You go to investor-state dispute settlement. Is that going to be the end? Now, in some way, as Trevor again was saying, maybe it doesn't matter where that forum actually is or what its starting point it is. For everyone to be able to consider together what is going on is perhaps of tremendous value. And that leads on, I think, to something we're going to discuss further, which is great, we're all there. Are we only talking about investment? Are we talking about IP and investment? Might we also be able, say, to talk about IP, climate change, human rights and investment? And if I had managed to keep my screen going, I would have these pictures I was going to show you. One is a picture which is a barrier in the road, which just says IP rights, no, you're not coming further. The next one is a set of parallel roads, which I tend to use. We may say have IP existing in parallel with climate change, in parallel with human rights, perhaps in parallel with investment. And then I have this golden thread emerging when we have all our areas of law tied up together, and we have this one thread coming out together, maybe producing one final answer. And it's a long time since I was in practice, but yes, clients often just want an answer. They don't want 12 different disputes. They want one answer clearly, and perhaps ISDS provides an interesting way of moving towards that. And I've got some books and things if anyone would like to read, but obviously not tonight. And I'll send these through for circulation. So thank you, and many apologies for the confusion with the technology. Thanks.
No, thank you very much. So now I will make one question for each of the participants, but please feel free to jump in if you want to add something. So the first question I was addressing to Mr. Cook, and it has to do with the fact of that, I mean, he was mentioning that one of the main features or advantages of going to arbitration for an IP dispute is that you can put a multi-jurisdictional dispute on one single procedure. And I mean, I also really like this about arbitration, and you were telling us about how the substantive law could be whatever the parties will agree on, and that they could even agree on deciding the case in one single national law and applying this or enforcing this award in different jurisdictions. And one of the questions would be like, I mean, in a way, this is why we signed so many agreements, right? Like the World Trade Organization had the TRIPS, and in Mexico, like we are signing also an agreement with the European Union. We signed one. We have the big one with Canada and the US, and we are supposed to sign these agreements in order to homogenize our intellectual property laws and the understanding of the laws for the sake of the investors in general, no, so that the goods can circulate freely, knowing that the laws have the minimum standards agreed on the agreements, on the national agreements. So I was wondering whether you see foreseeable that, okay, nevertheless, I understand that the national courts have different, like slight differences on how they understand these agreements, no? Especially like, I don't know, in the European Union, the German court, I mean, the German courts do bifurcate the cases regarding patents, no? Whether like in other countries in the European Union, they don't do it. So aren't we just moving towards like a more international understanding of the rules of intellectual property? On how does this work in practice? Have you ever seen this in an arbitration with multi-jurisdictional issues of IP, Mr. Cook?
Yes, I have. And indeed, I had an arbitration where, you know, there were there was a US side to it and a European side to it. And the lead lawyers who were fighting, you know, there were international law firms involved, But really the main arguments were being advanced by the US lawyers. They were driving the case. And there's a feature of US law, of patent actions in the United States, which is a way of avoiding having juries to make too many sort of assessments about or construe claims. There's something called a Markman hearing where the court, as opposed to the jury, construes the claim. And so you get the various arguments as to what the claim term means, and the court says this is what the claim term means. Now, we don't have that in Europe. You don't have it anywhere else in the world, to my knowledge. But in this, because there was a US aspect to it, they wanted a claim construct hearing as the US case. And one of the parties said, well, can't we have it as the European side of the case as well? And I said, well, if one of the parties wants it, if the other party is not resisting it too much, if we're going to have the same, if we're going to be running these US and UK cases in parallel effectively, why not? And so I had a Markman hearing, a claim construction hearing in relation to a European patent. So I was adopting a procedural feature of the United States system in a European environment. So that was one very clear aspect. And I think, we do see a tremendous, even though obviously intellectual property is national or regional in nature, we are seeing a much greater awareness by intellectual property tribunals of what other tribunals are deciding. And I think, for example, now in Germany, if you're litigating a patent which has been litigated in parallel proceedings elsewhere in the European Union, in the EPO, if you're going to come to a different decision from that in the EPO itself, from that in these other any one of these other jurisdictions, you have to explain why. So, what you're certainly finding now is a much greater awareness of how other jurisdictions are handling these things, admittedly in the European context, within a fairly sort of narrow framework where we're all operating under the European Patent Treaty, or under harmonized rights at an EU level. But I think there is a much more greater international awareness, and courts are gradually converging in their attitudes, I think.
Thank you. Thank you very much. For the first round of questions as well, my next question is directed to Alejandro Garcia. Can you please tell us more about the interim measures when we have an intellectual property arbitration? Do you think they are better and faster? Once we decided to take our dispute of intellectual property to an arbitration, what are the chances to get a proper interim measure? Are they going to be faster than a preliminary injunction? Thank you.
Thank you. I suppose, of course, let's assume there's an arbitration clause. So it would be an agreement, most likely a contractual dispute. You would have an arbitration clause. Now, the issue you face in most cases with an arbitral tribunal, with arbitration, is that you need to have an arbitral tribunal first. Now, so emergency arbitrations and so procedures in some rules, but that is the issue. Is just can I get an arbitral tribunal quick enough if I want an injunction? Because, and that is the reason perhaps why sometimes some IP lawyers say to me, well, why is IP arbitration or arbitration IP disputes is not as good as litigation? Because for many of them, it's a litigation is a race to secure an injunction. Okay, so if you get the injunction first, that's it. That's what you want, and you want criminal sanctions if someone doesn't comply with that injunction. So, an arbitral tribunal, first of all, you need to establish a tribunal. It might be have emergency mechanisms, which still can be very quick, but still you have an order that is issued by tribunal that sometimes doesn't attach the criminal sanctions that you have in an injunction in court. So in that respect, I would say that in general, litigation is probably better, but it's not incompatible though. It's not incompatible because you can have an arbitration clause, but still in most cases you would be able to go to court to secure an injunction. So it doesn't close the door. An arbitration clause doesn't close the door to an injunction. Simply you can go to court and then you take to dispute to the arbitral tribunal. So in general, I suppose there's a question on how national courts would construe an arbitration clause in the meaning, but most, even some rules say expressly that this wouldn't prevent a party from securing injunctive relief before domestic court. So yes, I think probably, and if the key driving force for a party is to secure injunctions, probably even an arbitration clause is not the best of ideas. Now, arbitration, so some of the things that Trevor have mentioned is that has other benefits, confidentiality, sometimes the possibility of deciding a global dispute before a single forum. Because the thing is that although in many cases, say trademarks and patents are rights, domestic rights, how you sort of economically, how those rights are, if you wish, traded, how the rights are exercised, and so on. The commercial part of that is global nowadays. So that is the inconsistency where you have local creatures operating on a global level. And I think arbitration allows you to do that. And it's a really, I think, excellent solution for that type of situation. Multiple rights fragmented, one single forum to decide that. But that is not, it doesn't work for every type of right. So I think there's a lot of thinking when one decides whether arbitration is the best thing, or even when you have an arbitration clause, whether you need to commence arbitration now, maybe you seek an injunction and commence arbitration afterwards.
Thank you very much, Alejandro. And now, continuing with the first set of questions with Professor Brown, you were already telling us what are your views and the differences between trademarks and patents in regards to investment, and the fact that both of these rights are sort of negative rights. That's how you call them now. That the person has an opposition to them, like they have the right to oppose to them, and how. So then, in this sense. With the other rights that you're saying that in your picture they are parallel, such as human rights or the right to health, how can we bring all of these rights into an arbitration procedure? Like clearly the cases that you talked to us about, they were referring specifically, the tribunal was reviewing specifically one of the fact that IP is considered an investment and that is not being treated with the minor standards of the investment that they should be treated. But in the case of the Philip Morris, the issue was more about we are considering health to be like the fact why we are allowed to minor. I don't know if to say like minor. To put down or to lower down your right to have a trademark. I don't know if you can tell us a little bit more about this before.
Yeah, sure. So I think it depends on where you start. So for example, that final point you last made, you still have a trademark. That trademark has not been taken away from you. And if one sees the trademark as the right for Philip Morris to stop any other tobacco company selling cigarettes called Marlboro, say, that type of example, they can still do that. That is what trademark law does. It enables you to stop anyone using your trademark or something similar to it without your consent. And patent enables you to stop someone using the subject matter of your patent, your innovation, without your consent. The odd thing with the plain packaging cases is that the legislation which was passed didn't remove that power. It didn't enable anyone else to use it, which may be what we might see, say, if someone brought about a compulsory licensing regime in relation to COVID. It simply said, you're not allowed to use it. So that was that sort of quite odd situation that we see there relating to what the trademark actually does do. Then there's the question of, well, when the plain packaging legislation was passed, that if we perhaps had assumed that there had been a diminution of the value of the trademark, when is the country allowed to do that? And I see there's some discussion in the chat as well. So often one might argue we're doing it on the basis of our constitution, we're doing it to protect human rights, we're going to pursue environmental goals, for example. And these might seem totally reasonable questions. However, the question is, how relevant is that to the ISDS dispute? And I think there's two main angles by which one can look at that. One is it might depend on what your agreement actually says. And we are seeing, for example, in CETA, there's more and more reference to environmental type clauses there. That almost does that. I'm going to frame it as a defence, but no, it's not a defence. A specific reference to that. And there's also a tremendous amount of work is being done, bringing in another area of law, international law, interpretation of treaties, for example. The fact that if you have obligations under human rights treaties and under climate change, when one was interpreting the obligations under the investment agreement, is that a way of bringing in human rights in terms of interpreting the proper scope of the obligation which other countries have? In my book, there we go, there's my book, you can all go and buy my book. I did some work, I got some guidance from Gloria, thank you, but it's all, I take all responsibility for it. I prepared some suggestions that if countries did want to develop clauses in ISDS, when we might accept that IP could be a relevant asset, but when we are deciding, has there been denial of justice, etc., that this wouldn't be so if you were looking to the Paris Agreement, looking to international human rights treaties, for example. And that's lots of fun, and I hope that comes about in real life, but that's very, very far from what Trevor and Alejandro are doing in real life. The risk for a country, I guess, if they're looking at, they've signed up some investment agreements which do not mention human rights, protection of the environment at all, but they're under strong pressure through the goals that they are trying to deliver, perhaps through their constitution. I think if one takes a very, very narrow view, I think they're taking a risk. And again, Trevor, Alejandro, I'd love to know what you think. And I think that's almost the main problem that we see with ISDS. It can be narrowing all the opportunities that a state might want to take to follow up its own problem. Trevor, you were waving.
Well, I did have a comment on that. I just wanted to throw in that the right to property is a human right.
Indeed it is, but not unlimited.
No human, well,
less than any others.
Human rights are questions of balance.
Indeed. Yes, absolutely.
And perhaps if I may chip in also, so ultimately, the question, I mean, sort of, I'm not saying I'm going to be a black letter lawyer, but you tend to say, well, let's have a look at the treaty, and you have a sort of golden generation of treaties, is sort of 1990s Energy Charter Treaty, that type, first half of the 90s. For lawyers, when you sue in a state, those are the best treaties because they have very few wording, if at all, in relation to, say, health, etc. So the protection is very significant. Now, but those were the agreements that states agreed to conclude. Now, there's a second and third generation, say generations that are 2000, so particularly even NAFTA have that element, saying it linked particularly to the international minimum standard of treatment. So you have some treaties that have included elements that expressly deal with health, safety, and limit to an extent the rights of investors. But ultimately, it depends on what the state agreed to. And it's not a question, and I think sometimes the question shouldn't be viewed as something they say the state can't do that. State still can do it. The only thing is that, of course, they would have to pay compensation, and of course that's perhaps not very palatable. But sometimes paying compensation is better than, say, not being able to do something. And some states do a calculation. They say, look, I'm going to do it anyway. For example, Spain in relation to renewable energy. So I worked for Spain and defended Spain in 2 first cases, but and I'm not going to say anything that I shouldn't be saying. But when you look at sometimes countries say like they take a measure that might affect loads of different investors, but still they have to do it because they think it's a policy. They end up sometimes paying compensation. They lost some cases, and now even Spain concluding arrangements with investors to settle cases, and a lot of investors are actually accepting those offers by Spain to settle those cases. So in a way, even if you think that some treaties can be very protective, I think states can find a way to say, look, well, they might sue me. Not everyone would sue you, but the state still can take the measures. So the question is compensation, and sometimes one gets confused to say, no, the state can do it. They only will need to pay. So
yeah,
which is not
I think
great
that's right. Yeah, and I think that's when it can be interesting when one sees the question of countries at different levels of development as well, because some countries perhaps may be more willing to pay, maybe or financially able to pay than others. Yeah. And Trevor, I realized exactly when I got cut off, because I think I got cut off just as I was saying that there was a human right which covered IP. So there you go.
Thank you.
Yes, maybe this that Alejandro is saying about Spain, this is something that all states should learn from, no? That it doesn't matter that the agreement is already there. We can still have this exchange with the investors so that there could be a win-win situation. And I think as well, this is what arbitration is trying to bring into the topic of IP, specifically for multi-jurisdictional cases, no? That it is probably better to have one single dispute rather than several litigations all over. Well, at least this is my idea of what it should be, no? But you must know better what the clients actually want, and Trevor and Alejandro.
Well, I suppose it's an interesting reflection on the case which Abbe mentioned, the second case she mentioned, the Eli Lilly Canada case, that it raised the international profile of this particular issue, the sort of this utility threshold in Canadian law. And whilst Eli Lilly themselves may not have won, it's interesting to note that a couple of years later, the Canadian Supreme Court actually effectively changed the law.
Absolutely. Yep, I think that's it. And that's, the idea that it wasn't, well, depending on the side of the fence you're on. And I think maybe why some people are scared, because even if you win, do you really win? And I think that's such an important debate. And I think it's only starting. I'm not sure everyone is yet really speaking to each other across the different sides of the debate.
And just a comment on sort of sometimes concerns about COVID-19 claiming, look, I doubt any sort of pharmaceutical company would be prepared to sue a country in those circumstances. For a company to sue a state, it's a big decision.
Remember South Africa.
Well, but I mean, you never know. But I suppose that it is. But it wouldn't be. So very few companies, I would think, would stomach the backlash in terms of PR. Sort of instead suing. I think sometimes big companies resort to investment treaty arbitration only in extremely serious cases, if they pretty much have to leave the country, stop operating, I think. Otherwise, they wouldn't do it, particularly in circumstances where they get really bad publicity. And I think sometimes one should bear that in mind too. And sometimes I have discussions with clients and they will say, look, only if the risk is going bust, I would sue a country. So only the most extreme. So it might try, but I think the reputational harm can be significant. So I think in practice, probably I don't think we're going to see many claims in relation to, say, if, for example, COVID-19 patents need to be sort of a compulsory licenses and so on. I doubt, I don't know, Trevor, what do you think? But I doubt you would see a lot of, investment treaty cases commence in relation to those.
No, I think the problem with COVID-19 treatments, and in particular vaccines, is not an intellectual property issue. It is actually having the resources and the manufacturing resources to actually produce these things on the massive scale we do have. And I think that's what we're going to see with COVID-19.
I think that's right, but I think we have been there before. When I was shouting rudely about South Africa, HIV/AIDS, South Africa passed legislation in the late 90s, talking about permitting parallel importing, talking about compulsory licensing. It got sued by Big Pharma. The legislation was possibly valid. There was certainly actually no base for Big Pharma to raise the claim. I absolutely agree with what Alejandro said. It was the biggest mistake I think Big Pharma ever made, because human rights activists woke up, disastrous reputational damage, which I think precipitated the Doha Declaration, which confirmed the right to do compulsory licensing. So I think companies, I know it's a long time since I spoke directly to one, but are very aware of the risks which can come to it. What I think we're also beginning to see now, really welcome other people's thoughts, is the rhetoric is exactly as Alejandro has been saying. The WHO set up a pool much more quickly than has done for any other type of disease. There's a very strong pressure. We need to get something developed. We need to stop IP being a barrier. And we also need to get roads, nurses, doctors, supply chain fixed, because those were the standard answers which is often being thrown about. The problem isn't the lack of the AIDS drugs, the problem is the lack of roads. And that may or may not have been true. But I think now we're seeing a much more collaborative approach to try to solve the problems, which I think can only be the way forward.
And maybe it is perhaps because all the eyes of the world are on this, no? Like you said, while probably, and in its moment, it was with AIDS, it was only the problem of South Africa, probably, and the rest of the world didn't back it up, I guess. Okay, so yes.
I think that has to be, just to be fair to the pharmaceutical industry, you do also have the medicines patent pool. You have these initiatives which license at very low royalty rates to people, and tiered licensing structures and things like that. They don't necessarily hit the high headlines, but they're there.
No, that's extremely fair. And also there's the whole fact about we need patents. No one has ever come up with an alternative to encouraging the innovation and the investment in the first place. So as I said, I'm a dyed-in-the-wool patent lawyer, but it's how we find these balances. And I think often, as Trevor said, that the balances that sometimes are there are often actually not shared as much as they can be. So one sees maybe some quite blanket statements that we must have patents, that means innovation. And it's perhaps not quite as straightforward as that.
It's not as straightforward, yes. Now I would like to talk a little bit about the Unitary Patent Court before we pass with the questions from the audience. So for our audience that maybe is not related to what is the Unitary Patent Agreement in Europe, already several years ago, probably 7 years ago, they signed this agreement that there were going to be one unitary patent court to solve the patent issues in the European Union, and it involves one single law and one single court. The single court will have several seats in different countries, and they would have division depending on the specialization of the patent that was going to be let's say that was in a dispute, depending if it was a technology patent, if it was a biotechnology, if it was health, etc. However, the Unitary Patent Court would also provide for an arbitration court, or if I may say that. While this agreement is still valid, the fact that the United Kingdom withdraw from the European Union, it has been affecting the UPC. But in general, for our discussion today, this would mean exactly what Trevor was already advancing on, and that we have been discussing, that the multi-jurisdictional procedures solved in one single forum was going to be available, at least for people that would trade in the EU. Comments on that, please.
Okay, yes. Well, I mean, the one problem in a sense is that it is limited in its jurisdiction to the new unitary patent, and also to bundle European patents which have not been opted out of it. So in its initial years, at least, it is going to be just another court, and you're going to have national courts. But I mean, the question of jurisdiction is quite an interesting one when you come down to its provisions relating to arbitration, because I provided the Unitary Patent Court as an example of or the Unitary Patent Court agreement as an example of an agreement which permits for arbitration with effect inter partes, but not effect in rem. And when you read the relevant article of the UPC, it says, however, a patent may not be revoked or limited in arbitration proceedings, which reflects that. The trouble with the Unitary Patent Court as an arbitration mechanism, as an international arbitration mechanism, is that it is limited in jurisdictionally in what it can actually do. Because when you also look at the provisions which set up the Patent Mediation and Arbitration Centre in the Unified Patent Court, you see it say, the centre shall provide facilities for mediation and arbitration of patent disputes falling within the scope of this agreement. And that means the only things that fall within the scope of that agreement are unitary patents and non-opted out European bundle patents. And that means not falling within the scope of that agreement and not susceptible of being arbitrated under the mechanisms of the Unified Patent Court are European bundle patents which have been opted out of the agreement. And also, every country in Europe has its own national patent system. It may be applying the same substantive law as the European Patent Office, but it is actually a different system, and it is not within the jurisdiction of the arbitration centre established under the UPC agreement. So I'm afraid, you know, it's a nice sort of soundbite to say they have an arbitration centre, but really, unlike, for example, WIPO or the ICC, it is constrained in what it can actually arbitrate, and so really provides little or no benefit in that respect, and is potentially misleading in a sense if they promote it without reflecting on the true limits on its jurisdiction.
Sorry, Trevor, but then you also said that in an arbitration agreement, parties are allowed to say what they want to put into this, what they want to put into the dispute. So wouldn't it work that they just say, our seat for arbitration is going to be this arbitration center that is part of the UPC?
I'm not sure they can do that, because I'm not sure the center itself actually has the jurisdiction to take on something outside its jurisdiction. You know, WIPO, for example, the WIPO Mediation Arbitration Centre doesn't have this, if you like, this self-imposed limitation on its powers. So, you know, whatever the parties may want, I don't think the centre itself can actually legitimately go outside what it's been, the power it's been given under the agreement itself. And, you know, as an international agreement, it has it has an interesting status as an international agreement between members of the European Union anyway. So, and between only some members of the European Union, because of course, you know, a major European country, Spain, is not actually a party to it, because Spain disagreed with the linguistic rules associated with the agreement. So anyway, we shall see.
And that's interesting, sort of, if I may chip in, sort of similar to what happens with IIJ arbitration, because sort of IIJ has certain limited jurisdiction, and if the dispute doesn't fall within the scope of IIJ, which is Article 25 of the IIJ Convention, IIJ might say, well, fine, the dispute is, for example, something that falls within the scope of a treaty, but if it's not, and then we go back full circle to the concept of investment, but if it doesn't involve an investment, curious to what investment is, but so there's some take the view it's an investment for the purposes of the IIJ Convention, which it relates to economics, i.e. sort of a commitment, development, sometimes so the Salini test. You can't do it, and parties can't enlarge, even states individually can't enlarge that jurisdiction of IIJ. So it might be reaching something that is similar. So if it falls within that, then it's fine. So which is rather limited. But I haven't looked into the Unitary Patent Court arbitration. But if that is the case, IIJ is a similar precedent to that.
Thank you. Abbe, any comments? Okay. So now I'm going to give the floor very briefly to Gloria to portray the questions that we have from the audience to present.
Okay, I have to say that I'm very sorry. I have a very hungry husband making a lot of noise in the kitchen, so I am very sorry for that. I have two questions. I'm going to combine them. One is mine and another one is from the audience. And it's kind of the dimension of human rights without really being, but I think it is really the underlying ethos of these two questions. The first one is more hypothetical and is for Alejandro and for Abbe. Talking about the Spanish cases, one of the reasons, and Alejandro will remember this very well, while it didn't play a big role in the arbitration cases itself, one of the reasons the regulatory changes affected so much the renewable industry is because there was a certain country producing very cheap technology, while the investment that was taking place in Spain was mostly from European technology. So what happens is that the Kingdom of Spain realized that there was somewhere else in another continent cheaper technology, which obviously will amount to perhaps better, cheaper subsidies, let's put it this way. And I was always surprised that they never argued that, but arguably they could have said that there was some sort of those regulatory changes amounted to an indirect expropriation. And I'm really just speculating here. I'm just playing around with the argument. But Abbe mentioned that IP sometimes is too strong, and maybe it seems too protective of companies and investors, which, let's say, are the few rather than the taxpayer, the citizen who pays all these disputes. But in these cases, Abbe and Alejandro, I cannot stop thinking that maybe there was a climate change argument that it was pretty strong that the investors could have used. And they didn't do it, and I feel like they lose momentum to do it. I am not encouraging any new potential country to now use that argument, but I do think that that's the counter argument when we see IP as this, very strong kind of father protecting pharmaceuticals or international companies. So I don't know what you guys think about it, and maybe just so that I don't talk too much. The other question, which is very interesting, and I have seen myself more of as a citizen rather than as an academic, but it's true. In Mexico, there has been this progressive or trend of international companies trying to copy or trying to elucidate to some Mexican indigenous designs, so completely outside climate change, but indeed related to human rights. And one person in the audience asked, how do you how could you bring this? You know, there are international companies. Obviously, there are no arbitration agreement between these international companies and these indigenous groups. And maybe it's not for the indigenous group to bring these claims. Maybe the right answer is it would be for a state to do that. But I don't know whether if you're in experience, you have seen that happening already in another country, in another jurisdiction. And those are my two questions, kind of human rights related.
I suppose that if you want me to deal with the first question, it is interesting because I think investment treaty arbitration is not necessarily something that sort of can be against interest of the world at large, if you wish, because the thing about and sort of I defended Spain, but it was against Italy in one case. In that case, part of the pleadings was that part of the submission said, well, the incentives that were created by the state, in this case Italy, were part of the commitments, you know, to combat climate change. And that's why they have those incentives. And some people sort of, companies invested relying upon those incentives in the field. Of course, and Gloria said, of course, it happened. That technology actually, solar panels from China were much cheaper, and then some states said we're paying too much. But ultimately, and it's an interesting thing. Apparently, the reason why solar panels became cheaper was because of Spain, because it was the incentive sort of the technology developed very rapidly thanks to what was going on in Spain. So in a way, it is, if you think things are complex, because you say you have sort of incentives afforded, then people rely upon those, they invest, the technology improves, and then you say, well, but you change, things change, the state sort of Spain probably say they adjusted the system, and then some investors are unhappy and they sue. But that's why you think, in a way, it's not necessarily something they say is against the interest of people. It might be sort of actually, so investors invested because they thought, well, if things go wrong, we have a treaty. So I think it is, if you need to look at things in a from different perspectives, and you can see that things are not as simple. I don't think anybody really is has an easy life in here. So in the sense of saying, well, look, I invested, rely upon this. Also, states, things change. When the state realized in Spain it was a massive deficit in terms of the payment of the subsidies, and so the state took measures. So sometimes you can't really, it's not easy to say you are the one to be blamed. Now, what investors say in those states is say, look, you promised to us something, and we relied upon those promises, and we spent an awful lot of money. And we want to be compensated because the rules of the game have changed. Now, the states have said, no, we haven't changed the rules of the game. And some boards have said, actually, you knew this could be changed. So then it gets complex. But I think it is not easy to say, for example, this is creating an issue. No, I think personally, I think sort of these treaties that protect investment are a good thing in many respects, Now, some and even many states think they're good. So, for example, I think, if I'm mistaken, I think so. Is the working group 3 or 2? Is just sorry of UNCITRAL, is the reform of the system, and sort of I think Chile, Japan, and maybe Mexico are also countries that say we need to improve the system. It's a system that works. We don't want to get rid of it. Some other countries have said, well, we don't want anything to do with the system. My personal view is a system that has worked, has created investment. And Mexico, for example, they say thanks to NAFTA, received a massive amount of investment. And that's why perhaps Mexico has been sued many times under NAFTA, but they defend themselves and say, well, but it is not perfect, but receive a lot of investment. So as I said, I mean, you have so many different aspects to look at investment protection, but to me, it's a system that has benefited many states.
Okay, Professor Brown?
Thanks. Yeah, I would agree with all of that. To pick up perhaps the point about the indigenous materials. So I think it would depend on exactly how this did pan out. Firstly, the whole question about indigenous art traditional knowledge is a very, very live one within intellectual property. Not least, is it in fact an intellectual property point? As we've been seeing, it might be unclear what intellectual property is, but it's a private right that someone controls. And in a lot of indigenous communities, this is not what the traditional knowledge is either. It might be secret, it might be something which may continue on for the community. But because often what we may have been seeing, and whether to go back to patents, this is a bark from a particular tree or a particular perhaps Maori representation. This might be reproduced in t-shirts or films, which tend to bring it into the IP world. So one way of that for years has been trying to be solved at the World Intellectual Property Organization, again, trying to move towards a treaty on traditional knowledge and folklore and genetic resources. And there's lots of ways of trying to stop that type of problem, but it hasn't got anywhere yet. But even if it did, this would be more perhaps about, would the indigenous community own this right and could they stop anyone else using it? The other side, and I may have misunderstood, but what might happen is that if we had a situation when maybe we had say a multinational came in and maybe they got a trademark over a representation perhaps, or maybe they tried to assert copyright over it. And then maybe we had the Mexican government saying, you're not allowed to do that. You're not allowed to do that because we have chosen to protect our heritage in this particular manner. If that were to happen, I think that could be framed as an ISDS point, subject to the big point, of course, that this would have to be being done by, it would be someone coming from outside into Mexico to do this, rather from a local company doing it. But I think that might perhaps work, and then we would have an intellectual property right, and the investor would say that, hang on, you took my right away. You said I wasn't allowed to have this right at all, and perhaps depending on the facts, in contrast to the trademark situation, it's not just you can't stop anyone else using it, it might almost be actually physically removing that right from you. So that perhaps, again, Trevor, Alejandro, thoughts really welcome. Perhaps that could be framed as an ISDS point, and then that would again absolutely depend on what the actual agreement we may be talking about said, in terms of what could be protected. It did make any reference to human rights, but then also there's perhaps the point about interpreting any other obligations under the Vienna Convention that we might look at.
Yes, well, I mean, it would certainly be open to Mexico and to the Mexican government, should it so wish, to actually introduce some sort of national type protection. But the problem which the question asks is, what happens abroad? And unless one can actually export that idea abroad, then what one can do may be rather limited, other than in the context you suggested, Abbe. What one does start to see, however, is that certain countries are starting to introduce their own protections for traditional knowledge, and rather than, if you like, looking at this from a top-down point of view and trying to get buy-in from WIPO, they're starting to establish these at a national level and say, well, and then when they start to have agreements and trade agreements with other countries, they can say, well, what about you protecting our things in reciprocally? So, I think the answer probably starts at home, in a sense.
With that, I have to agree. Mexico and probably other countries that we are rich in traditional knowledge, we've been failing our culture to rightly protect it, even in the meetings with the WIPO, and it's also because we don't agree. First of all, I'm not an expert on this, but from what I learned is like the first thing to agree on is like who is the owner, who is going to be the representative of this of the IP rights, because is it going to be the community? Like in many in Mexican communities, it could be the chaman, or is it going to be the state? Who is going to be the representative of those rights? So that's one of the main areas to look into, because we are trying to put on this, let's say, world of the law, the world of the law inside of more traditional way to see the world in general, I would say. I guess, Dr. See, you have a last comment, Professor Abbe?
Just to say, yes, absolutely. I think it's exactly as you say. It's a IP is a very Western construct, even though there has been some recent change, so it doesn't necessarily fit. Brazil, I know, has been very active in this, and I know they've experienced exactly the point. But I think it's quite proactive, engaging with the community, and that leads to the question: who is the community? Who leads the community? If the community does have a leader, and from an Australian Aboriginal perspective, for example, that logic just doesn't work either.
I think we have one more last question of the audience.
Yeah, one last more, and this is for Trevor. And I think this question has a lot of dimensions: arbitrability, the tribunal's powers, etc. So I try to dilute the question in a simplified manner. Hopefully I manage. So let's say we have a dispute where the tribunal rules on the validity of an IP right, particularly the outcome of that arbitration award is that IP right is invalid. How far are the effects of that arbitration, the agreement? Is it only for the parties? I know the answer, but I'm not going to say the answer. Or the arbitration tribunal can actually tell let's say, the Mexican authority about that decision, about the impact of that invalidity. So Trevor, if you might enlighten us.
It's an interesting question, because it leads to a lot of other aspects about this. The arbitral tribunal is constrained by the rules under which it is operating. If it is operating under the WIPO rules, which are very strict about confidentiality, it can say nothing to anybody outside the arbitration. Some other rules historically were rather more lax about this. And if the parties didn't particularly specify confidentiality, then the arbitral tribunal might have had some leeway to do this. But generally speaking, the trend has been to follow WIPO's lead, actually, and to impose greater confidentiality on these sort of arbitrations, on inter partes arbitrations. I'm not talking about IIJD arbitrations or things like that, which are public. And so in those arbitrations where a right is held to be invalid, that, on the face of matters, is a matter between the parties, and the members of the public and the Intellectual Property Office does not get to hear about it. Strictly speaking, in the US system, they ought to be told, but nobody seems to do so anyway. And it would be inconsistent with the rules of the arbitral tribunal anyway. So, I'm more as an arbitrator, I'm more afraid of the rules of the arbitral tribunal than I am of some particular facultative provision in the US Code. So this does raise another interesting public policy issue. Is it right that parties keep, because you're dealing with, in an intellectual property right, you're dealing with what in a sense is a public right, and which has, a right to exclude against other parties and things like that. And yet it's been found to be invalid in this arbitral proceeding. You might say, well, isn't there some sort of public policy reason why this should be made known to everybody? Because otherwise the rights owner can just go off and sue somebody else. and perhaps, you know, they don't have the right evidence, they have a different argument, this, that, and the other, and win against that other party, even though they've lost against that first party. Now, I take a fairly robust view about this. I say it's no different to a private negotiation where somebody is accused of infringing an intellectual property right, and that person says, I have a knockout piece of prior art, takes it to the rights owner and says, okay, I won't let anybody else know about this, I won't tell anybody else about this if you give me a royalty-free license. And I win because I'm in a privileged position with this royalty-free license, and you win because you keep this invalid IP right. And that is life. That happens. That happens in ordinary negotiations. And I don't see that arbitration should be held to a different sort of standard than those which apply to ordinary negotiations.
Go ahead, Professor Brown.
Yeah, Trevor, I would absolutely agree with that, but some bells just started ringing in my head, probably incomplete bells, about settlement agreements and competition law. And I probably know not a lot more than, than that, but there has definitely been a problem that in that context you do settle and the competition regulators have become involved.
No, you're absolutely right. Some settlement agreements, and in particular those which involve payments by the rights owner to the infringer to keep off the market for a certain period of time, have been found to be bad by the European Commission and have been questioned in the United States under competition law. Yes, I mean, settlement agreements are open to challenge under competition law, potentially. And again, I would say, you know, an arbitration award which had that sort of consequence should be no more or less open to challenge. And if you have a private agreement between people which is not actually known to the competition authorities, well, if they get to know of it, then you face the consequences of that. But I don't think we should introduce a special regime for arbitration which gives it some sort of wider, which requires it to apply a different standard. I accept competition law can apply. And we saw that to an extent, of course, in that Sanofi-Genentech case. You can't exclude competition law, but I don't think we should hold arbitration to a different standard to private negotiation.
It would be something sort of applied on an ad hoc basis, I suppose. So, for example, I think the real issue would be if you have, say, for example, a number of licensees, and you have a dispute with one, an arbitration, and then you say to that, then that award, so suppose that the IP is invalidated and that licensee becomes a free of charge license, and then the other, you know, licensees will say, well, hang on, I have an issue here, I suppose. But arbitration is the answer. I suppose the other licensee should have to sue you too. So in practice, you know, the many different iterations, I think, this could have a lot of ramifications. I think competition law certainly is an issue, but again, is something that probably you would say need to deal with once you have an award. What the award says, what is the nature of the validity. So it's too complex, but it might be, of course, ramifications or things that are the unknowns maybe.
Excellent. Well, here's then another reason why confidentiality, it is actually an advantage of arbitration. Yeah. Well, thank you very much. We reached our limit time. Thank you especially to our speakers of today. We were really thrilled to host you virtually, and to our audience for following us. Thank you as well. And yeah, we'll see you in another time, hopefully.